close, by the way. Let me see. Okay, well, fourth place with 219 points, Amity University. Third place, 245 points, University of Exeter. Second place, it was 1 point more than the previous one, was Hamad bin Khalifa University. And first place is Middlesex University M with 255 points. So Middlesex University and Hamad bin Khalifa University will go to the finals. Thank you, everyone. And yes, applaud to all yourselves. You did very well the past 2 days. If the judges are available now and they're all present, please proceed and start the finals. And for the ones that will be watching and observing, please make sure you all mute your microphones and the video. Thank you.
Thank you, Delvin. On behalf of all the judges, I think, can I just say thank you to everyone who's taken part. I hope you've enjoyed it, and well done, especially to all those people who made it to the semi-final, and congratulations in particular to who has made it to the final. Could I just ask, just repeat what Delvin has said, that everybody who is not speaking to just mute themselves so that we can hear everyone clearly. I think, just to make it clear, that Middlesex M are going to be the appellants and Hamad bin Khalifa are going to be the respondent. I'll give you a sort of 30 seconds or so to get yourselves organised.
Mr. Presiding Judge, whilst the teams are doing that, I should make a declaration of interest, or at least a declaration of prior knowledge. I have previously judged Hamad bin Khalifa University, and I've lost track of the letters. I may have judged Middlesex M. So may I make a composite declaration and hope that both teams are happy with my continued participation and that I don't need to recuse myself from the panel.
I should make a similar declaration that I have both judged Middlesex M and Hamid before. So I make the same declaration.
I don't think I've judged any of them.
Well, you may end up as the sole judge then, Peter.
Unless anyone has any questions, then before we start, then I will invite the senior counsel from the appellant, Middlesex M, to begin the final moot when they're ready.
Your Honor, just a minute. Let me set if I may set up.
That's fine. You can take a couple of minutes just to get yourself organised.
Your Honor, am I audible?
Yes, I can hear you.
Thank you. Good afternoon, members of the bench. I am Madhub Chaturvedi on behalf of the appellant, Mr. Leith Payne, and along with my co-counsel, Friana Guster, we shall address the two grounds of appeal, respectively. I shall begin with the first ground of appeal regarding the jurisdiction of the DIFC courts, and my co-counsel Friana shall address the second ground of appeal regarding the mistake in the contract. we plead to the court to allocate 17 minutes as speech time and 5 minutes each for rebuttals.
That's fine. Thank you. Please proceed whenever you're ready.
Is it okay? Your Honours, the case at hand is amongst the appellant, Mr. Leith Payne, and the respondent, Ms. Razrani, regarding a trade of a cryptocurrency named Yapple on an online trading platform named Clevity. Clevity, as a platform, operates on a distributed ledger system, which uses a network of nodes located worldwide. One such node of the network is placed in the DIFC. Clevity as a platform allows users to engage in algorithmic trading, a practice in the financial markets since the 1990s, under which the appellant has designed a software named Beta, by which it offers to sell a Yapple at the average price of all the sellers in the market. And in the event there are no sellers in the market, it offers to sell at an inflated price with the objective to earn a better profit. Likewise, the respondent also engages in algorithmic trading by the use of program Alpha, under which it buys Yapple at the best available price on the market. The Clevity platform also regulates its users by making sure they have at least $50,000, a minimum margin of cash in their accounts. Any accounts below this margin are automatically excluded from trading on the platform. On 10 June 2022, the platform went under regular maintenance, which gave rise to a glitch under which the maintenance team mistakenly increased the minimum cash margin of $50,000 to $200,000. As a result, the only users on the platform were the parties, the appellant and the respondent. Though the error was rectified within 30 minutes, in that window, the appellant's program Beta and respondent's program Alpha concluded an electronic contract to sell 100 Yapple for a price of $250,000. Both the parties were asleep when this transaction took place, and the Clevity platform autonomously transferred the relevant monies and coins to the respective parties. It must be noted that that none of the parties reside in the DIFC. The appellant resides in the Sultanate of Oman, whereas the respondent resides in Dubai mainland, outside of the DIFC free zone. Additionally, it is undisputed between the parties. Apologies for that. It is undisputed between the parties that the disputed trade was concluded at 250 times more than the prevailing market rates. And the liability of the Clevity platform is not an issue to be discussed in this forum. With these in mind, the council would like to begin its arguments on the first ground referred to this court regarding the jurisdiction of the DIFC, Digital Economic Code, on hearing the dispute. To address this, the council shall make two submissions. Firstly, regarding the relevance of a node in the DIFC, and secondly, regarding the interpretation of Article 5A1B of the Judicial Authority Law of the DIFC, which has been referred to by the Code of First Instance and in providing jurisdiction to the court. If it may please the court, the council shall begin with its first submission.
Please do.
Thank you. Regarding the node, regarding the relevance of a node in the DIFC, the Council shall first explain what a distributed ledger system is, in the light of Clevity operating on such a system. A distributed ledger system, or DLS, is a decentralized system that supports recording of encrypted data and processing transactions and validating them over a network of nodes or computers located as spreadly or as narrowly as possible. This definition is supported by the Dubai Financial Services Authority glossary module, version 54 of May 2022. Furthermore, each node on the DLS acts as a mean of processing information and exchanging of information on the network of the nodes. In other words, the nodes operate as a collective entity rather than a single operation. Hence, the recognition criteria of a DLS being decentralized, not located in one place specifically. This definition is supported by the UK Jurisdiction Task Force's legal statement on crypto assets and smart contracts. The definition can specifically be found on paragraph 29 of the document, which is also included in the appellant's bundle submitted. Continuing, the relevance of a node to establish jurisdiction has been rejected by the New York case of Alibaba Group Holding Limited and Alibaba Coin Foundation in 2018 in the New York District State Court. The issue in the case was regarding whether the court had personal jurisdiction solely due to the presence of a working location of a host of a website in the New York City. The court held that a presence of the host of a website does not provide jurisdiction to the case, does not provide personal jurisdiction to the court, though it may have subject matter jurisdiction, but that is not the dispute. The DEC at hand surely has subject matter jurisdiction because it is established to hear cases regarding digital contracts and digital economic disputes. Regarding the personal jurisdiction of the DEC, or the analogy of the Alibaba case is applied by holding that if a host of a website does not have jurisdiction does not provide jurisdiction for the court to hear the case, similarly, a node of a DLS, of a blockchain technology DLS, does also not provide jurisdiction to the DIFC to hear the present case. This is support. If the council may refer to the analogy provided in the Alibaba case, where if the node started giving jurisdiction to the courts of that area worldwide, the presence of hundreds of nodes located across the globe will increase the risk of jurisdiction clashes across the world.
Counsel, there may be a risk of jurisdiction clash, but is that more a risk which is theoretical than practical? Because as soon as a jurisdiction claims, a jurisdiction claims jurisdiction over the case, then surely if other jurisdictions were attempted to be engaged, then there would simply be you'd simply get an injunction on the basis that a court was already seized of the matter, and the matter should proceed in that court unless that court, for whatever reason, relinquishes jurisdiction.
Your Honor, I duly apologize, but may you please rephrase your question?
Yeah. If your concern is that there could be any number of jurisdictions which could hear this matter, but if I'm sorry, I wonder if people could mute their microphones. Thank you so much. Your concern is jurisdiction clash, but once one court has the matter before it, then why could the other party to the case not go to any other court in any other jurisdiction and say, I'm very sorry, but for example, in this instance, the DIFC court is adjudicating upon the matter, and we request you to stay your proceedings in any other jurisdiction pending the outcome of the DIFC court, or the DIFC court, for whatever reason, relinquishing its jurisdiction, thereby enabling the matter to proceed in another court. But that way you would have structure to the process and there wouldn't really be jurisdiction clash.
Your Honor, addressing that question, I would like to include the fact that users occasionally engage in jurisdiction shopping, by which they send applications to courts which use laws which support their claims, and as opposed to jurisdictions which are neutral to both the parties. And hence this seems to be in opposition to the natural laws of justice, by which courts must be neutral to both the parties. Though the courts operate in neutrality, however, the laws in which the claimant sends his applications may create unfair results, as opposed to if the claim was sent to a different jurisdiction. And hence, the Alibaba case, where the New York court held that a node does not give jurisdiction, because for the same reason as the users may engage in jurisdiction shopping and relocate themselves worldwide. Hence,
thank you,
Thank you, Your Honor. Hence, in conclusion, Clavity's node in the DIFC is not sufficient evidence for the DEC to conclude that the disputed trade contract was concluded or performed in the DIFC, because the node serves as a mere medium of information exchange rather than a location in the DIFC for the finalization of contracts. And hence, this concludes the Council's first submission. And moving on to the second submission, the Council shall address the interpretation of Article 5A1B of the Judicial Authority Law. Article 5A1B states that civil or commercial claims or actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized or performed within the DIFC, emphasis, or will be performed or is supposed to be performed within the DIFC pursuant to express or implied terms stipulated in the contract. The interpretation of these words, partly or wholly concluded, finalized or performed, shall be the main focus, and interpretation of these words must be in line with other DIFC laws that guide on the application of the laws of the DIFC. In the present case, Law number 10 of 2005 of the DIFC provides a test to establish jurisdiction in commercial contracts. The test, though it relates to the establishing which law governs the contract, however, there have been scholarly articles from numerous scholars located in the UAE, which guide that these laws, which provide guidance on law governing the contract, can also be used to establish a jurisdiction in absence of any express agreements between the parties. Law number 10 of 2005, specifically Article 16(5) of the Act.
Those analyses are relevant here, where the parties have agreed amongst themselves that if the DIFC court is going to hear this case, that it shall apply DIFC law, so that there is, as it were, no dispute about governing law. The parties have said, if this court has jurisdiction, it will apply DIFC law.
Yes, Your Honor. The issue at hand is that whether the court has jurisdiction or not. And in discussing whether the court has jurisdiction, the laws the law number 10 of 2005 can be applied in arguing how the court can establish its jurisdiction with an express consent of the parties or the lack of it thereof. At present, the three criterion referred to in Article 16(5) of the relevant law state the tests fail as there is a lack of express option between the parties upon the jurisdiction of the DIFC, and a lack of evidence regarding the physical address of the parties' accounts on the Clevity platform, and additionally, the lack of evidence regarding the location of Clevity's head office. And hence,
let me put this proposition to you. As you read it, Article 5A(1)(b) is engaged where a contract is partly concluded or finalised within the DIFC. Isn't it in the essence of a distributed ledger that each node acts as an indelible record of the transactions, and so it only functions because it's got numerous parts that together amount to the series of records? So isn't the recording of these transactions on the node in the DIFC an essential part of the sort of transaction that the parties were engaging in, because they were expecting their transaction to be recorded on every node in the Clevity system? And therefore, isn't that enough to say that the contract was at least partly concluded or finalized within the DIFC?
Thank you, Your Honor, for that question. Regarding the location of a node in the DIFC does not confer the contract to be partly concluded in the DIFC, given the fact that the transaction may have been initiated on the transaction may have been initiated on the contract on the node in the DIFC. However, it is the network as a whole on which the contract has been concluded. This does not confer a single, the node does not act as a single entity of the network. The network is the entity as a whole. Hence the notion of decentralization of the system. Thus, the contract being recorded or being processed on a single node does not confer jurisdiction to the DIFC to hear the present case. Hence, in the light of time, the Council shall conclude its submission by stating that under the close connection test stipulated in Article 8(2) of DIFC Law number 3 of 2004, the residence of the parties is a major criterion to establish jurisdiction. The Council will restate the fact that none of the parties reside in the DIFC. The appellant resides in the Sultanate of Oman, whereas the respondent resides in Dubai mainland. Thus, the DIFC cannot have jurisdiction under the close connection test. In conclusion, the presence of Clevity's node in the DIFC does not substantiate the first instance court's argument of the disputed contract being concluded, finalized, or performed in the DIFC. Lastly, the court must interpret Article 5A(1)(b) of the Judicial Authority Law in line with other DIFC laws which guide on the application of the DIFC law. With this, the Council shall conclude its submission on the first ground, and the junior co-counsel Friana shall continue on with the second one. Thank you very much.
Thank you very much for your submissions. I would now like to invite the senior counsel for the respondent to respond on the first ground of appeal.
Honor. Good afternoon, Your Honors. My name is Aisha Bashir, and I'm the senior respondent representing Ms. Raz Rani. My co-counsel is Christina Altaratani, junior respondent, and we are representing Ms. Raz Rani against Mr. Leith Payne on appeal from the DEC. Your Honors, this is a case about an unsurplus party who set out to take advantage of a trade that would never have taken place if not for a mistake, and is seeking to benefit from a financial windfall resulting from said mistake of the other party. And this is unconscionable. Justice demands that when a party knows that their counterpart would only have entered the contract as a result of a mistake, the transaction should be set aside. Your Honors, We will be arguing on two stances. Firstly, that the Court of Appeal did not err in applying Al-Khurafi versus Bank Sarasin DIFC in concluding that the DIFC court had jurisdiction over the claim by Ms. Razrani against Mr. Payne under Article 5A1B of the Judicial Authority Law. I will be arguing this stance. My co-counsel, Ms. Al-Talatani, will be arguing that the trial judge did not err in concluding that it was sufficient for a purpose of satisfying Article 37(1)A of the DIFC contract law that Ms. Razi showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. Your Honors, proceeding with the argument regarding the jurisdiction, I would first like to highlight the Article 5A1B of the Judicial Authority Law, which states that civil or commercial claims and actions arising out of or relating to a contract or promise contract, whether partly or wholly concluded or performed within the DIFC. We would like to emphasize the aspect of partly or wholly concluded. Your Honors, on the issue of jurisdiction, we would like to firstly bring to your attention the geographical aspect of the distributed ledger and the nature of the node and distributed ledgers. A node, Your Honor, is an extension of the legal entity, giving the DIFC jurisdiction, much like how a bank branch, in the case of Sarasin, would be an extension. Your Honors, in the case of Bank Al-Khurafi versus Bank Sarasin, DIFC, a case within this court, that a branch was not a separate entity, but an extension of the legal entity. Therefore, the place of jurisdiction for proceedings to which the legal entity is a part shall include its extensions. This is under the assumption that the entity will be sued or sue in the place of that jurisdiction. This principle shall be applicable to our case, as Cleverty operated through distributed ledgers and did have a node within the DIFC jurisdiction, which we argue the node, similar to a branch, operates in the same way. Your Honors.
Can a node really, as a matter of law, be compared with a branch? Because when one creates a branch, one creates an extension of a legal entity in a particular jurisdiction. And so there's a legal act there creating something that's recognized with legal personality under the law of the place where the branch is created. Whereas a node is simply a piece of technology. It will be a server hosting some data. And companies might acquire servers by contracting with service providers in all manner of jurisdictions without taking necessarily the same step as extending their legal personality into that jurisdiction. So can we draw that sort of analogy?
Your Honor, while a node may seem like a simple infrastructure piece, in blockchain, it is a pivotal point of transfer. Nodes are used to simultaneously transfer the information, to initiate and conclude the different transactions. They are pivotal to the entire infrastructure of blockchain, and they are pivotal to the trades that occur with blockchain. Furthermore, Your Honor, the parties in our case are traders in blockchain and are aware of how blockchain works, one would assume, given that they have created algorithms to trade it. Therefore, they would be aware of how nodes are pivotal to this.
But counsel, why should a node play any part in the conclusion of the contract? Surely it is an instrument of record of what others have concluded. So the conclusion was between Mr. Payne and Mazrani, and the node simply acts as, I say, an instrument of record. Isn't that the case?
The nodes, while do record, are also used to, obviously, to find the information, to ensure its validity, and to then to verify the legality of the parties and such, which is a pivotal point of the entire action. And so sorry.
It's okay. Thank you.
Sorry, can I ask people to make sure they're muted? Samantha. Thank you.
So,
please continue.
Yeah. So the nodes are used to see the legality of the parties, to find the information and the data. So it is not just to record, but to simultaneously ensure that it is verified throughout, which is pivotal for the transaction to take place. And while this is only part of the entire transaction, as the rules we are arguing state, partly is still sufficient for the DIFC jurisdiction to be valid. Further, in Al-Kharafi versus Bank Sarasin, the court stated that as it was not a separate entity, but an extension of the legal entity of a main branch, similarly, in our case, the node itself is not a separate entity. They are points and links of data, and they hold servers and extensions to the main system, not a separate system. Furthermore, Your Honor, we would like to say that the DIFC has jurisdiction on the matter because as the DIFC states, it has jurisdiction over claims over claims that arise from events, incidents, and activities with regard to the transaction or contract, either wholly or partly within the DIFC. So when a particular commercial activity is carried out in the DIFC, which furthers or results in an incident or transaction, then the DIFC has jurisdiction over the claim arising from the incident or transaction, or if any essential part or element of conduct occurs that gives rise to the action, then the DIFC has the jurisdiction. And as I have argued earlier, it is an essential part to check for the legality and for the data, which nodes do simultaneously and in such an aspect. So in the case of Sarasin and Al-Kharafi, the contracts were accepted and instructions were sent to the DIFC. Similarly, in our case, the verifications were done by this node. Now, I understand that there are hundreds of nodes, Your Honor, and this would then, as the opposing counsel has stated, open up an idea of many jurisdictions and such. However, for that, the opposing counsel has not stated a jurisdiction that they would prefer in that regard. And furthermore, there has been the entire prospect that if forum shopping was something that we are worried about, then you would then want the best possible avenue to have this case heard. In our case, if we were to look at the citizenships of the clients at hand, you would have Oman. Your Honors, as I'm sure many in the cryptocurrency realm are aware, Oman itself has issued warnings against cryptocurrency for their own citizens, and they have warned against dabbling in cryptocurrency. Their courts are also not specialized towards cryptocurrency. Meanwhile, the DIFC has courts specializing in digital economy. They have courts specializing within this entire structure, and they are of good understanding and laws related to it. The Digital Economy Court rules 58.73 include distributed ledger technology as part of the Digital Economy Court's claims to the digital economy. Therefore, we argue, Your Honor, that this court is best suited to hear our case.
Well, yes, but counsel, you can't go forum shopping on the basis of which court has more experience. We have to surely follow the rules of jurisdiction as to which court is properly seized or has the matter. So I'm not too sure that arguing in favor of the Digital Economy Court as having expertise really is going to carry the day, but that's probably a matter for myself and colleagues on the bench.
Could I interject, Ms. Bashir? You started your submissions by referring to the justice of the case, and it might be open to this court to decline jurisdiction notwithstanding the exclusive wording of Article 5, if it could be shown that there was a more convenient court system and that could alternatively hear this dispute, and you've addressed some of those arguments. But I think that you haven't quite addressed Mr. Chaturvedi's points about the location of the individual parties being outside the DIFC, and the fact that, with the exception of the presence of the node within the DIFC, there's nothing else in this dispute that ties us to the DIFC. And it's that finding of jurisdiction that leads to the applicable law. So if there's no jurisdiction, and the applicable law point becomes moot. I'm thinking here that the law applicable outside the DIFC within the Emirate of Dubai and in the Sultanate of Oman is civil law, which is much closer to each other than they are to DIFC law. So why do you think that the balance of justice leads to this court hearing this dispute?
We believe that in the interest of justice and even convenience and fairness, that the DIFC should have jurisdiction, as it's the best suited forum for the matter at hand. The laws within Oman or UAE regarding mistake are a lot more broad when it comes to the issue of mistake. The laws regarding any sort of cryptocurrency itself are also vague, if not non-existent, and Oman has been hesitant towards the entire issue at hand, as I stated earlier. Therefore, when it comes to the idea of which would be best suited, it is not that this court is best suited, because the other courts would be lacking in that department, in our opinion, Your Honor.
Thank you. Please proceed. Please do.
Therefore, Your Honors, to conclude my arguments, I would like to say that the DIFC has jurisdiction over claims regarding the events, incidents, activities, which regard to the transactions, which further claims either partially or wholly performed within the DIFC. Due to the presence of the node and the nature with which nodes operate, there is a partial performance within the DIFC, and this court is best suited towards handling such a case compared to the other alternatives that could be considered. Thank you, Your Honors.
Thank you very much for your submissions. I'll now invite the senior counsel for the appellant for his reply submissions. Thank you.
Thank you very much, Your Honor, for the opportunity to rebut on the opposing counsel's statements. Counsel shall begin by stating the fact that subject matter jurisdiction of the DIFC courts is not disputed between the parties, as the appellant counsel concurs with the respondent counsel that the DIFC does have jurisdiction, does have subject matter jurisdiction to hear the case, as the court is established to hear the case of digital economic disputes. Addressing the points made by the opposing counsel regarding, firstly, the use of the Al-Khurafi case by the first instance court and the similarity of a node with a branch. Picking on the first one, the facts of the Khurafi case, the opposing counsel states that Khurafi case is very relevant to the present dispute. However, in the Khurafi case, the two parties were not located in the DIFC. Rather, they chose an office in the DIFC to come together and meet for the conclusion of their contracts. This is very different to a node wherein the parties are only engaging on an internet transaction and did not, by their agreement, choose the node of the DIFC to act as a processor of their information. Secondly, the point mentioned by the opposing counsel regarding that the node is pivotal to the contract, it is stated that the parties engage in an online transaction. if the node at the DIFC was turned off, which is very possible, then if the node was turned off, the DIFC would lose its jurisdiction, as the transaction could have been done in any other node present on the internet. Hence, the matters of jurisdiction should not be taken as lightly as a trivial matter of the presence of a node in the DIFC. Lastly, regarding the similarity between a branch and the node of a distributed ledger system, a branch is a whole legal entity, as rightly pointed out by Your Honor, Sir Matthew Watson, that a branch is a legal entity of its own very usually, and even for tax purposes, it is an entity of its own which pays tax in the relevant country it is established in. However, a node is a mere server, a mere computer. Personally, I can set up the computer I'm interacting with at the moment to be a node of the Cleverty platform. But would this give jurisdiction to the Dubai mainland courts to hear the dispute? Most likely not, because a mere presence of the node is very trivial and very trivial to the completion of the contract, as any node could be engaged in the processing, in the conclusion, in the validation of the contract or the transaction entered into on an online platform.
Does the trivial nature of the node really work in this sort of technology? Because hitherto, when one has been dealing with a business, one has been dealing with businesses that are centralized. They have head offices and, as we talked about, branches, and they tend to have a single location. But the essence of these sorts of ledgers is that they are decentralized. So they are by their nature diffuse. And there is a danger if one simply applies traditional principles to that one has the situation that nobody takes jurisdiction, because the presence in any one jurisdiction is regarded as ephemeral. So shouldn't we treat this new technology in a slightly different way and say, if any part of that technology is present in my jurisdiction, then that is enough on the statute, because I only require something to be partly concluded, that is enough to engage my jurisdiction?
Your Honor, regarding that question, I shall state the decision in a case not referred to in the appellant's skeleton arguments. The case of Ion Science in 2018, where the court held that the head office of the platform shall be the location where shall be the jurisdiction where the dispute shall be heard. Applying this to the facts of the case, the location of the Cleverty's head office. Now, of course, it is a decentralized system, and the jurisdiction is diffused all over the world. And having one, I apologize. Of course, the jurisdiction diffused all across the world. Cleverty on its own is an entity, and being an entity, being an organization, it must be placed somewhere. The council agrees that this distributed ledger system operates across the world. The platform operates across the world. However, the organization, the one which has the ultimate liability of the dispute, resides in one country, which is unknown to the parties. Hence, the appellant pleads to the court to find that the head office or the central management location of the Cleverty platform has better jurisdiction to hear this case instead of the DIFC courts. Thank you very much.
Thank you very much for those submissions, and to both senior counsel for their submissions. Can I now invite a junior counsel for the appellant to begin their submissions on the second ground of appeal?
Thank you, Your Honor, for introducing me. So my name is Fiona Khazda, as previously introduced by my senior counsel, Mr. Mother, and I shall appear as the junior counsel for the appellant, Mr. Leith Payne. So, Your Honors, as clearly mentioned, I will address the second ground of appeal, and I want to reinstate and convince this court to invalidate the decision of the judge in the court of first instance, and also support the argument of my co-counsel. As a result, confirming that in this case of the respondent Razrani and the appellant Leeds Payne, the court's conclusion was based on the reasonable man test, and we believe it is incorrect, on the basis that a unilateral mistake cannot invalidate the disputed trade, because the appellant did not have constructive knowledge of the respondent's position. And we shall make the submission opposing the respondent's views. Before moving on to my submissions, I shall reinstate the second ground of appeal and what it implies. The second ground of appeal implies that, did the first instance court error or make a mistake in concluding for the purpose of a claim to avoid the disputed trade? Was it sufficient for the purpose of satisfying the Article 37(1)(a) of DIFC contract law that Ms. Razi shows that a reasonable trader with the knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was a result of an error? In this case, Your Honor, I would like to present my submissions in response to the second appeal mentioned above. If it may please the court, I would like to proceed with my submissions now.
Please do.
Thank you. Your Honor, the first instance court did actually make an error in concluding that the claim to avoid the disputed trade, and it was sufficient for satisfying just Article 37(1)(a) of the DIFC contract law, that the respondent shows that a reasonable trader with the knowledge of these circumstances surrounding the transaction would have made sure and concluded that it was an error. Basically, what I'm trying to state is, in other words, it's not sufficient enough to show that the appellant, as a reasonable trader, had constructive knowledge of the mistake, which in fact he did not. Mr. Payne did not have any constructive knowledge. Instead, the court should have examined this programmer's state of mind while they were designing the program. So the relevant inquiry should have been looked upon whether the programmer was doing so with actual or constructive knowledge of the fact whether this relevant offer would have only been accepted by the party operating under a mistake, or whether the programmer was actually trying to take advantage of this. Moving on, if we look at Article 37(1)(a) of the DIFC contract law, it states, and I quote, "The other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake and was contrary to the reasonable commercial standards of fair dealing to leave the mistaken party in error." By looking at Article 37(1)(a) of the DIFC contract law, which I just quoted, there cannot be relevant mistake, as the respondent, Mr. Payne, made a mistake. Even if Mr. Razi made a mistake, the appellant, Mr. Payne, programmed better, he did not make the same mistake as her, or even cause her mistake, or could have known about her mistake. Hence, you can state that there are no grounds to avoid the disputed trade. And even if the court considers...
Is that quite right? Can I put this to you? What your client did was to program his computer program to trade in such a way that if there were no other people offering to sell at a highly inflated price. So wasn't he designing his program to operate in some circumstance where there might be something unusual happening in the market, like as happened here, a mistake on the platform? Isn't he trying to take advantage? Can't we infer that what he was doing, whether he was actually thinking of it, or a reasonable person in his position would have been thinking this, that what he was trying to do was to take advantage of some sort of problem in the market and then offer to sell at a highly inflated price?
So for the matter of fact, Mr. Payne did not program beta in such a way to take benefit from somebody else, or, he acted in lack of good faith. Instead, he has merely done that to earn general profit. In his state of mind, he has not done that to imply or take advantage of another individual or of another company. He's merely done that to earn profit. And if you look at other alternative circumstances, if there are no other users offering to sell Yapple, there could be different reasons. Maybe other users don't want to sell Yapple at the specific time allotted, or it wasn't there in the market at that particular instance. Mr. Payne did not have in mind saying that, yes, there will be an error which will happen, and due to which I'm making this thing in my program better. That was not his intention, and that's not why he programmed it. The mere reason he coded his entire beta program in such a way was just to earn profit if nobody else was offering to sell Yapple. And the reasons why nobody else was selling Yapple was none of his concern. So he didn't bother looking into why nobody else would be selling Yapple. But that is how he programmed it, just to gain profit, but not take advantage.
Well, counsel, state of mind really goes to actual knowledge. But when we look at the wording of Article 37(1)(a), which you've read, and you've noted, it goes beyond actual knowledge. It also includes constructive knowledge, i.e. Mr. Payne may not have known, but should he have known that having written his computer code and his operating instructions in the way that he did, surely he had constructive knowledge that it could generate a super profit. And isn't that therefore an intention that he had? And going on with Article 37(1)(a), the effect of the super profit, 250 times market price, is outside and contrary to reasonable commercial standards. Why doesn't it come within Article 37(1)(a) such that there has been a mistake?
So if we look at what the appellant did and why he did it, he has done it, as you say, he's done it to just earn profit. No matter the profit be of 1% or 250 times the percent, pursuingly, he didn't have intention to cause harm or cause anything in bad faith to another individual. He was merely there for profit. So even if it was blatantly just a bit of, even if it's not complete intention, but it was just a bit of intention, cannot be considered. Because the reason why he's programmed his beta in such a way was just to earn profit. And no matter what the profit could be, because he cannot look at every instance of what can take place. So for that reason, he's just done it to earn profit and not in bad faith for anybody else. If I have answered your question, have I answered your question, or is there something you would like me to elaborate on?
No, I think you've taken it far enough. And if I have further questions, I'll come back. Thank you, counsel.
Okay, thank you. If it's all right, I would like to proceed with my submission.
Please do.
Thank you. So continuing, if the court considers the reasonable man test, we can look at any reasonable trader who would look at these algorithm trades on the Cleverly platform, like Mr. Payne, could not have known or developed the awareness that the sale of Yapple was 250 times higher at the market price and it was abnormal. Thus, it contended that, the contract will still remain valid. And why we state this is supported by the point I'm supposed to make right now. So if you look at the majority of the court's appeal and what they stated, which comprised of the Chief Justice Sundareshwar Menon, Andrew Frank Boon Yong, the judicial assistant, Jude Prakash, another judicial assistant, and we look at Robert French, all of them stated in Coin Limited versus B2C2 Limited 2020 Singapore Court of Appeal that the disputed trade cannot be reversed and the respondent's claim should be dismissed. And why this case is very important shall be mentioned in a while and how it's related to us. So would your honors like a brief overview of this case to understand better?
No, thank you. But what I would be interested to know is why, given that that decision is not binding on this court, why we should prefer the majority's analysis over the minority, because obviously Lord Mance is one of the world's leading contract lawyers, and he concluded that one should assess constructive knowledge at the point that the contract is concluded. And if one applies Lord Mance's analysis, one tends towards the conclusion that there was a relevant mistake.
So it's not fair to just look at a unilateral mistake which Ms. Razi had gone into, because the appellant, when he programmed beta, he did not make the same mistake, nor was he aware or could have known about the respondent's mistake. And for the matter of fact, when the appellant programmed beta, he programmed it in such a manner that was constructive to what happened. So if anything, we should be looking upon Mrs. Razi and how she could have programmed alpha in a way better manner than to avoid any risk or risk management in that sector. Because in the Coin case, the current case's majority judgment is very important to look at or to understand at this programming functionality, because the judges have clearly stated that if you're reversing a trade, you'll be in breach of contract. And when you do this, the trades would be void. And it's clearly stated that, you cannot do something which is irreversible because it's already stated. And furthermore, I would like to add that in support of the majority of judgment which was made, they've also stated that it was made directly between the buyer and the seller. So a unilateral cancellation is a breach of agreement. And that's why I believe that we should apply the majority judgment and we should establish it in the current case of the respondent appellant. Because even though Mr. Mance, Judge Mance, is very important and he has a very significant site in contract law, the first instance court did err in rejecting the claim, and they should have relied on the judgment based of Article 37(1)(a) that it's undeniable that the disputed trade took via domestic algorithms because there was no human interface, thus preventing any possibility of actual knowledge on the part of the appellant. Because there wasn't any human interface, it was all automated, which was already pre-programmed. Hence, the majority judgment is absolutely necessary.
Thank you. Are those all your submissions then, conscious of the time? But
I would just like to add on briefly, if I have 2 minutes.
Please
I shall
do.
conclude. Thank you. So lastly, just to state and reinstate, the appellant could not have known that the disputed trade was the result of the apparent malfunction, as his program beta was coded in a way to sell Yapple at the price of the average price of Yapple. However, he has also instated that it can automatically offer Yapple for a highly inflated price if no other users are willing to sell. In conclusion, Your Honor, it is a submission of the appellant that the court did make a mistake in rejecting the appellant's claims for the reasons stated above, and that the contract is legitimate and it's not governed by the DIFC. Therefore, the claims should have succeeded. For the foregoing reasons, I respectfully request the court to find in favor of the appellant, and it is on these grounds we ask Your Honor to dismiss the claim made by Mrs. Raz Rani, the respondent. Unless I can be of your further assistance, this concludes the case for the appellants. Thank you.
Thank you very much for your submissions. And I would now like to invite junior counsel for the respondent to make their submissions.
Thank you very much, and good afternoon, honorable judges and respectable audience. My name is Janela Cristina Talatini, and I am the junior responder in this case. I will start by arguing that the respondent, Ms. Raz Rani, should have the right to avoid the disputed trade under DIFC contract law, law number 6 of 2004. I will then continue by arguing that Ms. Rani should have the right to avoid the disputed trade for unilateral mistake under the common law and under the law of equity, which, although not binding on this honorable court, I believe could be persuasive. Your Honors, at first instance, the Digital Economy Court did not err in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Razi showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was the result of an error. The DIFC law does protect the rights of parties who have genuinely made a mistake. A party may avoid the contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known, and the other party knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. I also thought, honorable judges, that the opposing party might try to argue that under DIFC contract law article 37(2), it was grossly negligent for Ms. Rani to commit the mistake, or that the mistake relates to a matter in regard to which the risk of mistake was assumed, or having regard to the circumstances should be borne by Ms. Rani as the mistaken party. Your Honors, Ms. Rani was not grossly negligent, and the risk that Ms. Rani was exposed to is aggravated due to the failure of the Clavity platform. Under normal circumstances, she would never be exposed to such a risk, and it was unforeseeable that such a situation would ever occur for 30 minutes only at a time when both parties were asleep.
Is that true that she doesn't run the risk? Because she programmed her program to buy at whatever was the best possible price on the market. So she took the risk, didn't she, that whoever was the best possible price on the market on the particular Cleverty market may not have been a good price by reference to the wider price for this cryptocurrency. And isn't it just, it's as it were a matter of accident that it was a malfunction with the program that meant that there was nobody else on the market, and so Mr. Payne's program activated its particular subroutine, because there could have been any number of entirely legitimate reasons why other people didn't want to trade on that platform, with the result that they were the only two. Didn't your client rather run the risk in just saying, I will buy at whatever is the best price on this particular platform, that the best price on that platform wasn't a very good price?
Thank you, Your Honor. Our client took a reasonable risk. She never assumed that the type of situation that she was placed in would happen. We highly doubt that under any normal circumstances, Mr. Payne's platform would be the only one selling. This situation only happened due to the failure of the software. She was not grossly negligent, and the risk she took it being well aware of the market conditions and knowing that under any normal circumstances, the value of the cryptocurrency would never increase 250 times higher than the market rate. Our client was well aware of how the market and the platform function, but she could not foresee that the platform would completely fail for half an hour and that the disputed trade would happen.
Could I just ask there, Ms. Safarafini, then isn't her remedy against Cleverty then for the error causing her loss? Why should Mr. Payne be responsible when it was Cleverty's adjustment to their software that led to that trading blip?
Your Honor, our client, Ms. Rani, she entered into a contract with Mr. Payne. So as both parties to the contract, our client has the right to request this from the party she entered into a contract with. And the mistake was between our client and Mr. Payne. Therefore, we strongly believe that she can raise this claim against Mr. Payne because he's the one who is trying to profit from our client's mistake.
Counsel, you say the mistake was between your client and Mr. Payne. Can you define, for the benefit of the court, precisely what you say the mistake between those two parties was?
So, Your Honor, the mistake was that our client, actually the algorithm that she created, entered into this contract with the algorithm of Mr. Payne. So under normal circumstances, had she known of the situation of the market, she wouldn't have entered into this contract at all. Was that transaction happening, let's say, face-to-face between Ms. Rani and Mr. Payne, and knowing the conditions of the contract and the trade between them, she would have never accepted the offer. So that is the unilateral mistake, honorable judges.
Thank you, counsel.
Thank you very much. I will continue by stating that the DIFC law is based on the UNIDROIT principles, and it is very similar to the rules of a number of common law jurisdictions. Therefore, this court may elect to be guided by these persuasive authorities, although you are not bound by these. I will now argue that this is a case of unilateral mistake under the common law and under the law of equity, and that Ms. Rani has the right to avoid this contract. In common law jurisdictions, including England and Wales and Singapore, unilateral mistake requires that one party has transacted while operating under a mistake as to a fundamental term of the contract. Algorithmic trades are, of course, novel and distinct in that the parties don't know what the terms would be until after the trading contract is made. In the case of Coin versus B2C2, the Singapore International Commercial Court's first cryptocurrency judgment was the first time a unilateral mistake was applied to an algorithmic trade, And the judgment recognized that the existing body of law needs to be, and I quote, meaningfully adapted to deal with this type of novel situation. The court judgment is relevant to our argument because it considered the question of how algorithmic contracts are formed. The majority opinion found that contract formation took place when an offer was made by one algorithm and accepted by the other, and that the parties agreed to the contract using the deterministic algorithms. And I'm quoting here from paragraph 97. Therefore, the parties were content to abide by whatever algorithms were built within the parameters of the program. So knowing about the mistake must be considered with reference to the person who created the algorithm when they created it up to the point the trade was made. Therefore, the question the court must consider today when programming the algorithm, did the programmer, Mr. Payne, create it with actual or constructive knowledge that the offer would only be accepted by a party operating under a mistake, and did the programmer act in such a way as to take advantage of this mistake? Your Honors, we believe that Mr. Payne did indeed act with the intention to take advantage of such mistakes. Otherwise, why would he put this condition in the algorithm that if no other seller was available, he would sell at such a highly inflated price, which was 250 times the market price?
Is it fair to say that that would only be the case if he was trying to exploit mistakes? Wouldn't that be the sort of thing that someone would program, not to exploit mistakes, but to simply exploit the lack of supply in a market? And in a particular marketplace, if there's no supply of a good or you're the only supplier of a good, you can effectively name your price.
Honorable Judge, we believe that under any normal circumstances, it would be close to impossible for Mr. Payne to be the only one selling Yapple on the platform, as there are many users, and this situation happened only because of the software failure. So it seems his intentions when he programmed the algorithm were to take advantage of such mistakes. That's why we are claiming that it's not just a matter of making a very high profit, it's also a matter of exploitation, something very close to a monopolistic tendency, which we believe should not be allowed. Mr. Payne was very well aware.
Sorry, counsel. What you just said in answer to my brother judge was that under any normal circumstances, it would be close to impossible for Mr. Payne to be the only person on the platform. Surely your argument depends on Mr. Payne thinking in advance about wholly exceptional and abnormal circumstances, and isn't that imposing a disproportionate burden on him?
Your Honor, we do believe that actually the burden here is on our client, Ms. Rani, because she never assumed that such a situation would happen. And Mr. Payne is acting here contrary to fair dealing, to fair trading. And we all know that cryptocurrency markets are very poorly regulated to date, and that many countries around the world are working on regulating the crypto transactions. Meanwhile, we believe that users and traders in cryptocurrency should be given protection by the law to make up for this gap in regulations. Because if we take the stock market, for example, which is quite similar to the cryptocurrency market, this kind of abnormal transactions would be regulated, would never be allowed to happen. A red flag would be raised somewhere and try to regulate and to find remedies and solutions for the losing party. Because Your Honors, we believe that this is not just Mr. Payne making a huge profit. We believe that this is exploitation, is taking advantage of a very, very unfortunate situation that the software failed and that there were absolutely no other users on otherwise a very active platform that were selling the currency.
Couldn't your client have mitigated the problem by simply including a provision in her program that said, I will buy at the best possible price on the platform, but not above, say, 10% above the market price? I mean, isn't really the risk borne by your client, because she sent a program out into the world empowered to bind her to contracts. And the only instruction she gave it was buy at the best possible price. And that's precisely what happened. She bought at the best possible price. It just transpires in hindsight that that was not a price that she would have really wanted to buy.
That is true, Your Honor. Our client could have built a better, I would say, more sophisticated algorithm. However, when she did build it, she built it being well aware of the market conditions and knowing that such a situation would never happen when there is only one seller, and that seller is with the intention of exploiting, selling us at such a highly inflated price. So yes, there was a mistake there on behalf of our client, and that's what we are arguing, that she should be granted relief for unilateral mistake. Because, honorable judges, no reasonable person in the same situation as our client would have concluded a disputed trade if the true state of affairs had been known. Unfortunately, we know the facts of the case. Ms. Rani was asleep when Clevity excluded all other users from the platform. She was indeed fully unaware of the unusual change in market conditions on the platform. And on the other hand, I emphasize, Mr. Payne, being well aware of the prevailing market price for Yapple, can easily deduct that the disputed trade, which happened at the price 250 times greater than the market price, could only have happened due to an error. And it is contrary to reasonable commercial standards of fair dealing to leave Ms. Rani as the mistaking party in error. Moreover, when Mr. Payne programmed beta to offer Yapple for sale at a highly inflated price if there are no other users, he did so with the intention to take advantage of other algorithmic traders such as Ms. Rani, who could have never imagined a situation where only one seller would be available and dealing at such a highly unfair price. Would Mr. Payne's beta program ever be the only one available seller in normal circumstances were it not for the software update? We highly doubt so, Your Honors. And why should our client pay such a huge price for something that was clearly unforeseeable, unprecedented, and ultimately caused by the mistake of a third party? No reasonable buyer would have concluded a disputed trade had the true state of affairs been known.
Could I just butt in there for a second? Because I think Lord Mance, in his dissenting speech, says that his reasonable personal model, he says, wouldn't be a creature of the common law, but would require equitable grounds. And then he says that it would cohere with both tort and criminal law. And I might be slightly unfair here, but I think it's, one might say that criminal law and equity are more discretionary than the common law, and they do all depend upon just in all the circumstances and other sorts of things, whereas the common law might be more automatic and perhaps provide more certainty and surety in its outcome. Do you not think that that surety and certainty of outcome would be something that your client would ultimately want, being a programmer and a trader of cryptocurrencies?
Your Honor, we believe that our client can be relieved both under the common law for unilateral mistake and under the law of equity, which was my next argument. I believe she can be offered protection under both these laws, and either way, a relief should be found for our client, because it would be unjust for her to pay such a high price for committing an unfortunate mistake. So if you may allow me, Your Honors, I will go further into defending our client's rights under protection she is given for unilateral mistake by the law of equity. And I will indeed follow the judgment in Coin versus B2C2, and I will state the rule of the law that the non-mistaken party must have had at least constructive knowledge of the mistaken party's mistake, and the non-mistaken party must have acted unconscionably relative to the mistake. And if both parts are satisfied, the contract is voidable. And I'm quoting here from paragraph 105. So the court needs to determine that this constructive knowledge is objective. Would the reasonable person have known of the mistake? And we do believe that, yes, indeed, Mr. Payne knew immediately when he discovered that the disputed trade was concluded that this could have only happened as the result of an error. Moreover, in the dissent, Lord Justice Mance discussed the purpose of equitable remedies under the law. So he stated that equity may supplement the common law to give the court's jurisdiction in cases where there is a fundamental mistake which is of a nature that is not covered by the common law, and to give jurisdiction also when the non-mistaken person lacks the requisite mental state required for the common law relief. Lord Justice Mans goes further and proposes that equity can be extended to unilateral mistake when the mistake is not strictly a subject matter term, but is sufficiently fundamental to justify equitable intervention where there is unconscionability. Lord Justice Mans says that equity conscience must be capable of being affected by behavior in seeking to retain the benefit of the mistake once it is discovered. And we know that our client has the right to request Mr. Payne not to take advantage of this mistake once that he has discovered it. Also, Lord Justice quotes the case of digilandmall.com when he states that the court is entitled to intervene and grant relief when it is unconscionable for the non-mistaken party to insist that the contract is performed. So there are several precedents that Lord Justice Mans emphasizes upon. And he also recognizes that unilateral mistake is an exception recognized by the law to further the ends of justice. And it's of a similar character to the principles underlying the law of misinterpretation, of undue influence and mistake. He proposes that this was recognized in the case of digilandmall.com when the court said that the law should not go to the aid of a party who knows that the objective appearance does not correspond with reality. It would go against the grain of justice if the law were to deem the mistaken party bound by such a contract. Allowing the law to intervene in a circumstance-specific way, the underlying rationale is not a lack of correspondence before offer and acceptance, but is a principle of justice in this case. Lord Justice Mans stated that if the mistake and its outcome were in the term of a transaction in human terms, the reaction of any human trader viewing the transaction executed would have been that they were fundamentally misconceived, the result of a fundamental mistake that no seller would agree to in the prevailing market condition. Also, Lord Justice Mans found that it was never contemplated that trading could occur at deviant prices other than from an error. He stated that the key question is, can the law of unilateral mistake be applied in a manner that leaves out consideration of circumstances central to its application simply because the parties entrusted their dealings with without consciousness? We believe that the law must be adapted to the new world of algorithmic programs in a way that gives rise to results that reason and justice would lead one to expect. The introduction of computers, no doubt, carries risk, but I do not consider that these include the risk of being bound by an algorithmic contract, which anyone of learning would at once see could only be the result of some fundamental error in the normal operation of the computers involved. Computers are outworkers, they're not overlords. And this is what Lord Mans stated in paragraph 193. If it would be immediately perceived that a fundamental error had occurred, relief should be available. The proper approach is to consider, again, what would a reasonable trader have thought given knowledge of the circumstances, and relief in equity is necessary because a reasonable person, knowing the circumstances, would know there was a fundamental mistake. Otherwise, it'd be an unjustified windfall. It would be unconscionable for a trader such as Mr. Payne to retain the benefit of a major error as soon as he has come to learn of it. We plead to this honorable court and to the judges to give due weight to these considerations under the law of equity. It is clear that Mr. Payne had constructive knowledge of Ms. Rani's mistake, and Mr. Payne acted unconscionably relative to the mistake. We could not emphasize this enough. Any reasonable person, knowing of the circumstances, would know there was a fundamental mistake. Equity conscience must be evoked. It is truly unconscionable for Mr. Payne to insist that the contract be performed and seek to retain the benefit of an unfortunate mistake from our client's side. The reaction of any human trader viewing the transaction executed would have been that they were fundamentally misconceived, that it is the result of a fundamental mistake that no buyer would agree to in the prevailing market conditions. The law of unilateral mistake in equity must be applied even if the parties entrusted their dealing to computers without consciousness. The law must be adapted to the new world of algorithmic trades in a way that would ensure justice and fairness are preserved. It would go against the grain of justice, to quote, if the law were to deem Ms. Rani bound by such a contract. And with this, honorable judges, I conclude my statement. Please let me know if you have any questions.
Thank you very much for your submissions. To conclude the moot, I would like to invite junior counsel for the appellant to give their reply submissions.
Thank you, Your Honor, for giving me time to rebut. So starting off with what Lord Mance said, Lord Mance actually made an analogy that if two people came to the floor for a contract, they would have not concluded that the transaction due to the circumstances. However, the parties had removed the element on purpose and made a domestic algorithm in charge of transaction on their behalf, which was followed and was programmed, thus comforting the opinion that the majority of the judges is more appropriate as the state of mind of the programmer ought to be explored, as opposed to Lord Mance's reasoning that the parties could not conclude the transaction they had because they didn't come to the floor physically. One of the main reasons, the reason why we're here, is that this entire thing has happened without human intervention. So we have to look at it from an angle of having no human intervention. And we have to look at it from the state of programmer's mind and how the program was done. Also, I would like to state that when any programmer is programming their code, in such case, Mr. Payne programmed beta and Ms. Razrani programmed alpha, they have to make sure that they have explored, if not all, but most scenarios while programming it. So Ms. Razrani should have programmed her software in such a way that she should have been aware of the risks and should have kept a supplementary stating, as Your Honor had clearly mentioned before also, that above this percentage, I will not accept a transaction. And that should have been done from her side. The way the appellant did from his side, he clearly stated that he's going to sell Yapple at an average price. However, if nobody is there in the market, he will sell it at a highly inflated price. And the reason for this is all around the world. If anything has any lack of supply, it's usually gone for a higher price because it's less available. And the same thing happened in this case because Yapple was only present with Mr. Payne at the time of the malfunctionality. He was able to sell it at a very highly inflated price. So furthermore, moving on, I would like to state that the appellant had good faith. He has not done this in bad faith or lack of faith for anybody else. And he's just done this to have profit for himself. Neither is it his fault that he had more than the required amount at the percentage time, because the program says that he's supposed to have 50,000 cryptocurrency as a minimum amount, but they haven't reinstated what the maximum amount is. So if he has more than that, it's not his fault. It's Clavity's fault for making this error. Therefore, if the respondent is talking about this error, she should be directly facing Clavity and not the appellant. Furthermore, if Ms. Razrani made a unilateral mistake, the appellant did not. He did not make a mistake and he was not aware of the mistake. So at the moment, we can conclude by saying if a mistake was made by Ms. Razrani, it wasn't made by Mr. Payne. Therefore, you cannot consider a unilateral mistake taking place. Furthermore, the trader should be accountable for their state of mind while they're making the program. And as discussed previously by the junior counsel, she talked about the principles of equity. So there's nothing in the DIFC laws that state that the principles of equity apply to the DIFC courts. Furthermore, when we talk about the Singaporean case, Quinn versus B2C2, the principles of the equality function are present there. So the part of the judgment is not applicable to us. The law should not be adopted to exclude the functioning of the determining algorithm because that's the main sense of it and the state of mind of the programmer. Only that unproductive in taking of the law to the direction of it adapts and enhances why a program should be there. Should be there in the first place. Also, as mentioned by the junior respondent, yes, the appellant and the respondent enter into a contract. However, the mistake was made by Ms. Razrani and the Clavity platform had an error. There was no way to state that the appellant had a mistake or there was an error made by the appellant. So if the case has to go on in the future, it should be with Clavity. Furthermore, I would like to state that how can the appellant know of what could have been taken place in the future and what error would have taken place? And that is not something that can be held against the appellant. In this scenario, he was merely making profit based on what he had programmed. This is not in bad faith. I would like to end by stating that this entire case has to be looked upon with the state of the programmer. And for the foregoing reasons, I once again respectfully request the court to find in favor of the appellant and dismiss the claim made by Ms. Raz Rani, the respondent. Thank you.
Thank you very much, and thank you to everyone for all your excellent submissions. The judges are going to retire now and consider the scores for the final, and then we'll deliver them to Delvin so that they can be announced. We shall try and be as quick as we can be so that you're not kept waiting. But if I can ask my fellow judges to retire, and I'll see you in the other room, we can discuss.
Thank you.